The default rule regarding employment in the United States is that it is at will, meaning that an employee can be fired or can quit at any time for any reason or no reason. This rule can be modified by contract and is restricted in some respects by federal and state law, but in general still holds true. In Hillesland v. Federal Land Bank Association, the plaintiff argued for an exception. Elmer Hillesland worked at the Federal Land Bank Association of Grand Forks for nearly 3 decades. He was the association's chief executive officer for 10 years. Hillesland learned that 2 of the association's customers, Ray and Eva Westby, were in financial trouble and had an offer from another association customer to buy their farm. Hillesland reached out to the Westbys to offer financial counseling. Hillesland's conversations with the Westbys ultimately led to Hillesland's sons purchasing the Westbys farm. The association's board of directors approved the deal, but after the sale was completed, the Federal Land Bank of St. Paul, which supervised the association under federal statutes and regulations, investigated the transaction. The bank fired Hillesland for exercising poor business judgment, violating written standards of conduct, and damaging the bank's and the association's reputation. Hillesland sued the association and the bank, alleging breach of contract and other claims. He asserted that he had a contract for permanent employment to be terminated only for good cause. The trial court ruled against Hillesland on summary judgment and dismissed the case. Hillesland appealed to the North Dakota Supreme Court, arguing that the bank and the association breached an implied covenant of good faith and fair dealing in his employment contract when they discharged him.